Hello everyone. The unit that we'll be doing today is Law and Financial Crimes. My name is Shazia Khan, and I will be teaching this unit with you throughout. So there's 4 learning outcomes and then the assignment discussion. And this unit is a level 7 unit. So we'll be going through each learning outcome each week, and then we'll go through the assignment discussion. So before we go into learning outcome 1, I just want to give you a little bit about the unit information, and also go through the learning outcomes with you so that you've got a better idea of what's covered in each learning outcome. Okay, so the Law and Financial Crimes unit the aim of the unit is to enable you as learners to understand compliance requirements in financial services and markets in relation to fraud, corruption, money laundering, terrorism, and theft laws. You will also be introduced to theories and practices in the law of financial crimes, about statutory frameworks, financial services regulations, capital market, Fraud and Theft Act, and the criminal regulation. So you'll be looking at different elements of different statutes, laws, case studies in regards to law and financial crimes. So I'll go through the learning outcomes with you. The first learning outcome we're going to be doing, which is today's learning outcome, is to understand UK financial crime provisions relating to insider dealing and market abuse. Secondly, we'll go through understanding the impact of money laundering regulations on business and its international dimensions. And thirdly, we'll go through understanding the regulation and commercial policy issues relating to white-collar crime. And the fourth and final learning outcome is to understand the development of global financial crime and the international initiatives in regulating the area. For this unit, the assessment is a portfolio of evidence, and it's 4,000 words overall, which this will be discussed more in the assignment discussion session. And, you know, we will be looking at the different elements of learning outcome 1 to 4 in regards to completing this assignment. The indicative reading is a book by Ryder, 2015, Research Handbook on International Financial Crime, and Suster, 2013, Financial Crime and Money Laundering, Cranbrook, Kent, Global Professional Publishing. Some website links that you could use when completing the assignment or going through each learning outcome. Financial Services and Markets Act 2000, one of the main statutes we'll be looking at. Money Laundering Regulations 2007. The Proceeds of Crime Act 2002. The Terrorism Act 2000. Fraud Act 2006. The Theft Act 1968, EC Market Abuse Directive, and Office of National Statistics, Crime and Justice. And these we'll be using throughout all the learning outcomes. You'll be able to identify the statutes that relate to the learning outcome, but relate to the crime as well. So we'll be looking at more financial crimes, both in the UK and globally as well, and looking at the European side of it as well in regards to financial crime within the UK. Okay, so this is just a little bit about the module specification and telling you what we're going to do. Each time we go through the learning outcome, we'll go through the assessment criteria with you and the indicative content, so you have a better idea of doing that. Okay, so I'm just gonna finish off this, finish with this unit specification, and now move on to learning outcome 1. I'll just share that with you now. So if you have any questions, please don't hesitate to ask them whilst we're going through the slides, or if you don't understand anything. Okay, so the one we're going through, the first one after the unit specification, is the learning outcome 1. That's the first one we'll be going through. Law and Financial Crimes, learning outcome 1, which is to understand UK financial crime provision related to insider dealing and market abuse. And this is such a wide area that is quite globally, it's an area that's growing. There's lots of crime that is occurring financially through internationally and nationally. And there's lots of issues around market abuse in regards to that. So this is a wide area that's increasing every day. And now with the recognition and the implementation of AI, there's a big increase in that kind of crime, both internationally and globally. So the unit aim is to enable the learners to understand legal compliance regulations, requirements in financial services and markets related to fraud, corruption, money laundering, terrorism and theft laws. And we'll be, throughout the learning outcomes, we'll be developing them a little bit more as well, so you have an understanding of what we're doing. Learners will be introduced to theories, practices, and the laws, statutory frameworks, regulations, and the different types of laws that would apply to this form of money laundering, corruption, or terrorism and theft laws, and why there are laws in place to protect individuals and businesses in regards to these forms of financial crimes that occur. And like I said, it's a huge concern within nationally and internationally, and this keeps growing every day. So key terminology, what is financial crime? Financial crimes are activities carried out by individuals or criminal organizations to provide economic benefits through illegal methods. They're a critical issue in recent years, as I've said. They affect the GDP globally. Financial crime in the EU is called the Anti-Money Laundering and Counterfeiting of Terrorism, AML and CFT, and it deals with the implementation of anti-money laundering and trying to fight financial crime. A video here on what financial crime is, so you could have a look at that in your own time, and what the implications of financial crime are on a business or an organization. Indicative content for Learning Outcome 1, we're looking at the Financial Services and Markets Act 2000, Fraud Act 2006, Theft Act 1968, nature and characteristics of financial crimes, corporate scandals. So there are so many scandals out there that we can look at a little bit. Role of SFO and FCA, LIBOR, mis-selling, the misuse and abuse of corporate form, case studies such as Northern Rock, Tesco and HIBOS, Financial Services and Markets Act on insider dealing and whistleblowing reporting mechanism. Now, a lot of the case studies and additional information is available for you on Moodle to go on, so you can look at different sorts of reports and journals that are on there for you to look at in regards to the financial crime module on there. So financial crime, just an introduction to what it is and why it's widely so spread. Financial crime is an increasing concern, as I mentioned, for all financial institutions. It could be from the largest, organization to the smallest companies and partnerships. It's something that happens which is illegal. And is exposed and done throughout businesses, and it doesn't matter the size of the business. The impact is that it's there's two levels of it, and there are significant issues around that once it happens. Preventing and detecting financial crime is rapidly evolving to be one of their biggest challenges. So the impact of which extends well beyond monetary losses. It's reputational and brand, employee business, as well as regulatory senses. So financial crimes, it's an increase. There has been an increase, and it is still increasing, and more so now than previously before, because of the implementation of AI, and it affects organizations, not just the business, but it affects the organization's reputation, the brand, and it has a huge impact on the day-to-day running of a business as well. It could involve things like, like we said, it could be fraud, it could be money laundering, it could be terrorist financing, bribery and corruption, cybercrime, which is another area which is quite increasing in it. Identity theft, another one, which is quite a big increase. So these are some of the examples, that it's been, affecting an organization, be it small or big. So the organisation suffers, and it's recognised as, it could be recognised, financial abuse could be recognised by the police as a criminal offence as well, you know, and sometimes it is generally defined as that activity that involves like things like fraudulent or dishonest behaviour, and it's the whole purpose of it is to get and gain some financial implications out of it, even though you know that what you're gaining through this is you know, a criminal offence. You know, things like the biggest one that's going around, even though there's bribery, corruption, everything, money laundering is a huge one. You know, the illegal practice of trading securities based on non-public material information. So money laundering is a huge one. It's literally the concealing of any sort of funds without through a legitimate way of doing it, financial system. So it's one of the, and it's a growing concern, as I've mentioned, within UK and within globally as well. So 1.1, analyse civil offence according to the Financial Services and Markets Act. So the Financial Services and Markets Act was first introduced in 2000. And the, sorry, oh, it's just there. Financial Markets Act 2000, and it's the cornerstone of every financial services. It was replaced by a single UK statutory financial regulator, which is the Financial Services Authority, FSA, at that time, and has since updated on many occasions, most notably by the Financial Services Act 2002. Frequent changes to the Financial Services and Markets Act and other regulatory rules for financial services businesses can make it more challenging to keep abreast of the latest requirements, what are needed to comply with. So every time there's loads and loads of changes, you know, coming about, and that's due to, you know, the implementation of new information on finances, or it might be the implementation of, you know, new markets that have come in. So the Financial Services and Markets Act actually sets up the overarching framework under which UK financial services are regulated. So they must all follow that in regards to any sort of issues around the requirements of a business. The objective of the Act is to create public confidence in the UK financial markets and also in financial services businesses operating in the UK. It actually aims to ensure that UK markets for financial services are competitive and exhibit high standards of integrity, and financial services businesses in the UK should be financially sound and treat their customers fairly. So it's the whole point of it is to, you know, make sure that the business is following the regulatory body, but also meeting the requirements of being financially, you know, integrity and treating their customers fairly. So the civil offence of market abuse. One of the important differences between the Financial Services Act 1996 FSA and the FSMA, which is the Financial Services and Markets Act, is the introduction in the latter of the civil offence of market abuse. The term civil offence is used because there's how the government describes market abuse. Importantly, the penalty for market abuse, which is policed and enforced by the Financial Services Authority, FSA, is an unlimited fine or public censure and an unlimited obligation to surrender any resulting profits and to compensate everyone who suffered a loss. So, you know, the whole point of it is try to if anyone has suffered any loss, it implements that. The unlimited fine seems to make it a criminal offence, and the government has accepted that is a real possibility, that it would be treated as a criminal offence. So, you know, they need to be careful with that for the purposes of the European Convention on Human Rights, which looks at the human rights of the individual. The government has therefore provided some of the procedural protections which the European Convention on Human Rights in case of proceedings for a fine. So the next element we're going to look at is what is the offence of market abuse. So there are 3 different offences of market abuse. Misusing information which is not generally available to the relevant market, misleading the market, and distorting the market. However, behaviour will not constitute market abuse unless is likely as regarded by a reasonable regular use of the market concerned as a failure in part of the punitive abuser to observe the standard of behaviour reasonably expected of a person in their position in relation to the market. The condition is likely to prove to be very helpful to market innocents who would otherwise unwittingly commit the offence. Market abuse offence is committed by someone who requires or encourages someone else to commit the offence, and that would be in regards to the Financial Services and Market Abuse Act. So who would commit the offence? So importantly, market abuse can be committed even without intent to abuse the market at all. So in addition, it applies to all transactions in the prescribed quoted securities, even if they are over the counter, which is transactions. So in fact, it does not need any transaction at all. Melanie Johnson, of the Economic Secretary to the Treasury, actually made it clear that the debates in committee in the House of Commons that issuing a misleading press release could constitute market abuse. So it could go as far as, in the House of Commons as well. So accordingly, not only securities houses and banks, but also directors of quoted companies need to be aware of the offence. So they need to make it clear that it could be anyone. It could be anyone, and they need to make it clear that, they need to identify why this has happened and the reasons why this has occurred. 1.2, identify sources of law on insider dealing. So the Market Abuse Directive is referred to as MAD. MAD is a European Union legislation that aims to prevent and detect market abuse in the financial market. It was enacted in 2003 and later revised in 2014, making it a key component of the EU's efforts to regulate and maintain fair and transparent markets. So it needs to make sure that there's regulation between the EU as well, and make sure that the markets are dealt with and they are transparent, because that's one of the elements of it. In the UK, the insider dealing can be defined as the trading in organised security markets by a person in possession of material, non-public information, and has been recognised as a widespread problem that is extremely difficult, and guidelines that restrict insider dealing and tipping to eradicate some of the insider dealing is based on corporate information. It might soon be too soon to determine what effect assuming the Fraud Act 2006 has in it, which its arrangement don't have any significant bearing reflectively, and which since 2007 can be arrayed under the new arrangements, assuming we factor in the time allotment, which examination, the indictment regularly take the principal significant preliminaries are simply liable to be under the steady gaze of the courts. The general criminal law has always sought to protect the integrity of public markets. For example, Section 47 of the Financial Services Act 1986 outlawed misleading statements. So outlawed misleading statements and manipulative practices as unlawful interference with proper operation of the markets. The crime conspiracy to defraud was utilised to police the markets. In practice, however, these more general offences relating to interference with the market would not be applicable in a case of simple insider dealing unless there had been manipulation and fraudulent conduct. Until 1980, the restrictions on insider dealing in the United Kingdom were extremely limited. So we could, there wasn't many cases out there. There was no statutory prohibition of the practice, nor did the common law make insider dealing actionable. There was a case in regards to this, and it was the case of Percival and Wright, where the Court of Chancery held that a corporate director owed a fiduciary duty only to the company and not to its individual shareholders, and therefore the director was ordinarily not obliged to disclose information about the company to shareholders before trading with them. Nevertheless, to the shareholders before trade, if a director expressly or impliedly becomes an agent for one of the more shareholders in a particular transaction, the fiduciary duties arising out of the agency relationship may prevent him from releasing a profit on the acquisition of the securities to his own advantage. So, there are guidelines in place that need to obviously be taken in place when restricting any sort of elements of that. So, when we look at this element, we need to identify that the markets are there to restrict that kind of information. There are guidelines that need to be followed, and in instances, some organizations don't follow them. And if the Financial Services and Markets Act was not in place, to prevent any sort of manipulation or any sort of unregulated market practice, then, it would struggle. So again, looking at Market Abuse Directive 2003/6 EC, his aim was to ensure that European Union legislation keeps pace with market developments to combat market abuse on financial markets, including derivative markets relating to commodities such as gold or wheat. The UK MAR, which is the Market Abuse Regulations, makes insider dealing unlawful, disclosure, market manipulation, and attempted manipulation civil offences, and gives us powers and responsibilities for preventing and detecting any sort of market abuse. The criminal insider dealing is an offence under Part 5 of the Criminal Justice Act 1993, and criminal market manipulation is an offence under Section 89 to Section 91 of the Financial Services Act 2012. Now we're going to go look into 1.3, which is looking at evaluating the statutory frameworks and EC context on dealing with insider dealing and market abuse. So the Financial Services and Markets Act 2000 FSMA is a demonstration of Parliament of the United Kingdom. The demonstration made another administrative structure for the oversight and the board of the UK's banking and monetary administration's ventures. The goal of the enactment is to guarantee that UK market is reasonable and that everybody approaches full and comparative data on informed purchase and sell invoices. Their distinctions incorporate advancing the well-being and sufficiency of the organisation. Other eminent elements of the FSMA are the fact that the necessities of a firm are to be approved to lead controlled exercises, the punishments for market misuse. The guidelines encompass deceiving a market or financial backers. Following the distribution of these new guidelines, organisations were committed to assuming greater liability towards guaranteeing their exercises were consistent with the enactment. And that was in the book of Pham and Aulus 2020. Organisations subsequently required legal rather than self-guidance. This implied that businesses need to react to the refreshed enactment of the guaranteeing that consistent officials had adequate preparation and a sound comprehension of the significant administrative bodies. Consistent officials were likewise needed to skillfully impart the standards and their consequences for all impacted staff, and consequently the actual idea of consistent was changed and organisations started utilising it as a vital and dynamic administration. So the UK's Financial Services and Markets Act 2000 Section 6(3) broadly defines the term as any offence involving fraud or dishonestly, misconduct or misuse of information relating to a financial market or handling the proceeds of crime. Financial crime therefore covers a wide range of offences, including insider trading, money laundering, and also terrorist financing. The Financial Services and Markets Act 2000 states that the term of an offence is a behaviour, for example, under Section 6(4), that includes an act or omission which would be an offence if taken place in the United Kingdom, thus expanding the remit of the legislation to include conducts occurring outside. So looking at 1.4, it's looking at analysing, looking at 1.4, sorry, analyse the general offences of financial crimes under Financial Crimes and Markets Act 2000, Fraud Act 2006, and Theft Act 1968. The law pertinent to advertise misuse is set out in the Financial Services and Markets Act 2000 and 2000 FSMA. The definition of market misuse is intentionally drafted in expansive terms. It identifies that any sort of conduct that endeavours to invade actual practices or make bogus or misdirecting idea according to exchanging or working in monetary sectors. So it looks at the element of fraud, that there's laws in place in regards to that, and they have to be exercised in regards to misuse of any sort of market misuse. So things like the Commission of Market Users will in general identify with various exercises in forex extortion, labour control, insider exchanging, and high recurrence exchanging. Knowing the line, that the line is isolated, that what will and what won't be considered as market misuse is a fine one. Controllers are engaged to give nitty-gritty direction to associations and people working in the monetary administrations and markets on what exercises will be considered to be lawful. Much would rely on upon the exercise being referred to, and the the controller, which is the Financial Conduct Authority, implements the law concerning monetary administrations. Knowing a dubious exchange is one where there's sensible justification. This sensibility test is intentionally expansive, broadening the degree for the lead inside which sketchy exercises will got on. It's based on the reports that FSC will choose whether to seek an examination concerning the exercises. So assuming that the FSA conducts an examination concerning dubious exercises and finds it, including an explanation that the person itself has been engaged with market misuse or forcing a fine on those engaged with market use, they will typically go to the court and request this. A case example in regards to this is the case of individual charged with investment over QB trading, and there's a link there for the actual case in regards to this. And in this case, the Financial Conduct Authority has launched criminal proceedings against someone called Stephen Maggs of Sittingbourne, Kent, for 2 counts of fraud and 1 count of breaching the Financial Services Markets Act, FSMA. And just an update, in May 2024, it was a plea and trial preparation here, and Stephen Maggs pleaded not guilty in just recently to fraud by abuse of position and fraud by false representation. A trial date has been fixed for 3rd of August 2026. Mr. Maggs is alleged to have operated an unauthorized investment scheme called Cube Trading with the K, which received around 2.6 million from investors between the 1st of March 2019 and 22nd of January 2021. The FCA, which is the Financial Conduct Authority, alleges the scheme involved trading contracts for differences in foreign exchange, which is regulated, which is a regulated activity, and that Mr. Maggs concealed significant losses from investors. It was also alleged that he defrauded investors by misrepresenting how the scheme was operated and over the handling of investor funds. So he was, causing any sort of frauds in regards to that. Again, Mr. Maggs appeared at Maidstone Magistrates Court on 23rd of April, 2024 this year. The case was sent to Maidstone Crown Court for a plea and trial preparation hearing on the 21st of May 2024, which was quite recent. And Lee Maggs, it was identified there are 3 counts as to follow. First one was to carry on regulated activity, namely managing investments, whilst unauthorised, contrary to Section 19 and Section 23 of the Financial Services and Markets Act 2000. Then the second element was fraud by abuse of his position, contrary to Section 1 and Section 4 of the Fraud Act 2006. And thirdly, fraud by representation contrary to Section 1 and Section 2 of the Fraud Act 2006. And the offences normally for under Section 1 of the Fraud Act 2006 carry a maximum sentence of 10 years imprisonment. A person cannot carry on a regulated activity in the UK unless the Financial Conduct Authority, FCA, authorised or exempt. Breaching this requirement is a criminal offence which carries a maximum sentence of 2 years imprisonment. 2002 was by no means a quiet year for financial crime, from devastating cases of fraud to some hefty fines of anti-monetary laundering failings. 2022 saw some of the utmost shocking financial crime and money laundering cases and reports, which I've put an article up for you on Moodle to have a look at. So to look at the Fraud Act, it deals with a criminal offence of fraud. The Fraud Act is a primary piece of anti-fraud legislation in the UK and has come into force since January 2007. In contrast to any sort of previous legislation, the Fraud Act, the Fraud Act established a clear legal definition an offence of fraud for the first time in the UK, and for the main offences established by the Act, it removed the element of deception as a characteristic of this kind, and there are several new offences created under the Act, being Section 2, 3 and 4. The Act also creates new offences of obtaining services dishonestly and of possessing, making the supplying articles for use of fraud. So there's a lot being added onto the new Act, replacing the older Acts. The next Act is the Theft Act 1968. So Section 1 of the Theft Act 1968 provides for the criminal offence of theft. Under Section 1, subsection 1 of the Act, an individual will be guilty of theft if they dishonestly appropriate belonging, property to another with the intention to permanently deprive them of that. The role of the Serious Fraud Office, SFO, and the Financial Conduct Office, Financial Conduct Authority, FCA. Both financial services, Financial Conduct Authority and the Serious Fraud Office investigate and prosecute relevant offences within their remits. As such, the FSA and the SFO mutually recognise their independence, along with the need to conduct matters in accordance with the ambit of their respected statutory powers and responsibilities. So if they have any suspicions or they can carry out investigations, which are called dawn raids, at the premises of the firm or the company they wish to go into. Nature and characteristics of financial crimes. Financial crime can undermine social security systems and destabilise a country's economy, politicals and society. It has a profound impact on everyday life as it threatens the safety of financial systems. As underlined by the International Monetary Fund, IMF, various forms of financial system abuse may compromise the reputation and functioning of the financial institution and jurisdiction, thus weakening the financial system. Financial crimes could also lessen the country's ability to attract foreign investment, increase the volatility of the exchange market, or distort the allocation of resources and distribution of wealth. In some cases, its impact not merely social and economic, as it may threaten the very security of a nation. It may take the form of diversion by corrupted officials of funds destined to public services and infrastructure, or activities closely linked to organised crime and funding of the terrorist activities, which there has been an increase, and we're going to go through it. So corporate scandals of financial crime. We look at the biggest financial scandals of 2022. So in October 2022, the European Agency for Criminal Justice reported a doubling in cases of money laundering in the last 6 years in EU region alone, estimating that almost 2 trillion is laundered each year. And this is just the cases that are successfully reported and brought to justice. The clandestine nature of money laundering and financial crime could in effect make this figure a mere drop in a much larger, more troublesome ocean. So we're going to look at a little bit of the cases that we've got, the case examples. The first one is the Santander fined 108 million for anti-money laundering failures. So the FSA slapped one of the UK's high street banks with an eye-watering fine for anti-money laundering failures in its business banking division. As the country was winding down for the Christmas break, Santander executives were feeling the wrath of the FCA, citing significant failings in the period from 2012 to 2017. The Spanish bank was condemned for its poor management of their anti-money laundering systems, and their inadequate attempts to address the problems created a prolonged and severe risk of money laundering and financial crime. With Santander not disputing the regulator's findings and agreeing to settle, the 154 million fine, oh my God, such a huge fine, was reduced by 30%, bringing it down to 107.8 million. The next case study in regards to that, the scandal was, the next one was, the logistics firm's operators jailed for 36 plus years in 30 million money laundering plot. So 6 men were jailed in January 2023 following a 2-year investigation by the West Midlands Regional Organised Crime Unit for their roles in the 30 million money laundering operation. Genesis 2014 UK, which is a road haulage business, was the seemingly perfect guise for a large-scale money laundering operation that saw the firm's management conspire to collect and transport significant sums of ill-gotten cash from across the UK into London, where the funds were transferred and legitimised. A prime example of stages 2 and 3 of money laundering, layering and integration. Reflecting on the case, the Crown Prosecution Service said that the defendants were an essential distribution part of the criminal network, transferring the cash proceeds of criminal activity for the wider benefit of organised criminals, as well as for their own gain. So this went to the CPS, and that's what they identified when they were reflected on this case. Another scandal was gambling brand penalised for CSR and money laundering failures. So 888 is a gambling business known for its online betting brands, including William Hill, 888 Casino, 888 Sport, 888 Poker, and Mr. Green. Following an investigation by the Gambling Commission, 888 were ordered to pay a record-breaking fine of 9.4 million for failings in money laundering, due diligence, and social responsibility. The ruling came just 5 years after 888 was fined 7.8 million for its poor handling of their most vulnerable customers. Customers were allowed to gamble with large amounts of money without sufficient due diligence and source of funds checks. The company failed to identify players at risk of harm and failed to implement formal guidance on customer interaction from the Gambling Commission. Just some of 888's failures included not identifying players at risk of harm because their policies determined financial checks should be carried out after a customer had deposited £40,000, not carrying out customer interaction with a customer who lost £37,000 in a 6-week period during the COVID-19 pandemic, not carrying out source of fund checks until a customer had deposited £40,000 and accepting verbal assurances from customers of their employment income without requesting documentation. Contrary to their source of funds policy, one customer was allowed to spend a staggering £65,835 in 5 months without source of funds checks being carried out. Another famous scandal is the UK estate agents take £500,000 hit for AML non-compliance. 68 estate agents were publicly named by HMRC for their non-compliance with AML regulations in 2022. Fines totaling over £500,000 were dished out last year, along with bans prohibiting convicted individuals from acting as estate agents and community services sentences. That was quite a huge thing, with penalties being issued for failures in having the correct controls and procedures, internal controls, conducting due diligence and failing to apply for registration at the required time. The European Parliament warned of a number of shortcomings in anti-money laundering practices in the real estate sector. As real estate continues to be an attractive avenue for money laundering criminals, firms must double down on the anti-money laundering efforts and in-depth security of clients involved in property transactions. And finally, the last scandal was the Credit Suisse, guilty of money laundering charges, handed £1.7 million fine. One of the jewels in Swiss Crown Credit Suisse was found guilty and fined for involvement in money laundering related to a Bulgarian drugs ring in the summer of 2022. As the country's first criminal trial of one of the major banks, Credit Suisse, and a former employee were both found guilty for failing to prevent any sort of money laundering. Failings will ultimately enable a Bulgarian cocaine trafficking gang to clean its dirty money through the financial system between 2004 and 2008. At the time, CNBC reported the court found deficiencies within Credit Suisse, both with regard to the management of client relations with the criminal organisation and with regard to the monitoring of the implementation of anti-money laundering rules. A watershed moment in Swiss history was the case was seen by many across Switzerland as a sharp warning for the country's banks as prosecutors look to take a tougher stand against failings by financial institutions. The firm was fined £1.7 million and ordered to pay £15 million to the Swiss government. The employee involved in the case was handed a suspended sentence of 20 months prison sentence and a fine of money laundering. So these are some of the scandals and the biggest financial scandals and events that occurred in 2022 for fines and non-regulatory compliance. There's more that are on obviously the links that I've put on. Some of the articles you could look at in regards to this on law of financial crime is the article on financial crime in london.ac.uk sites, which looks at postgraduate laws on financial crimes. Another one which we referred to earlier was the publication on in regards to Northern Rock in 2009, and that looks at the elements of non-compliance in regards to financial crime then. And the other one, which is the link there, is regarding the prosecution between Tesco and SFO in regards to non-compliant dishonesty and in regards to financial crime, which you could link on. And these would be really interesting for you to have a read around these so you're able to identify and look at the elements of financial crimes in regards to them. The references we've used for today's session are just listed there. There's more additional reading on Moodle that you can go on for any sort of additional reading. Some resources there. So there's some books on there on criminal proceeds, anti-money laundering laws, audit and risk committee in financial crime prevention, capital markets and financial crime, white collar crime. So have a look at them in regards to that. If there's any preliminary, refer to ebooks and journals on Moodle for this unit. I've put some articles on Moodle that you could have a look at in your own time. Any sort of queries you've got in regards to any questions you've got about the assignment or anything, please email learnerwork@ukvarsity.co.uk. If you have any questions, email learnerwork@ukvarsity.co.uk. Submission of the assignment is normally done 2 weeks after the completion of the unit and is submitted via learnerwork@ukvarsity.co.uk. Please make sure you go on to Moodle to have a look at the additional journal articles that are on there for you to read. And now we've finished learning outcome 1, the next learning outcome on financial crimes unit, law and financial crimes, which be learning outcome 2, which is the next session. So please make sure, if you haven't got any questions or anything, we've finished this session now, and I will see you in the next session, which is learning outcome 2. Thank you for attending today's session.